Hi, this is Patrick Conroy, and we're going to be covering part 1 of chapter 13 in this video, contracts in writing. I split it up into 2 lectures, not because it's too long, but because they really are 2 topics covered in this chapter, contracts in writing and third-party beneficiaries. And I don't want you to sort of lump them together in your mind. I want you to be able to keep them separate. Okay. Now, the statute of frauds, it's a rule of the state law that requires certain types of contracts to be in writing in order to be enforceable. So it's state law passed by state legislatures and passed by 49 of the 50. We live in the 50. We don't have the statute of frauds, but usually it's because we have some other law that requires the contract to be in writing. So we've never adopted it in full. What is the purpose of the statute of frauds? Well, it makes it much easier in negotiating by requiring sufficient, reliable evidence to prove the existence and all the specific terms of a contract. You know, this is it. This is what's in writing. This is what we can show in the court. We are both clear on all the conditions and the offer and the acceptance. Because oral evidence can often be unreliable. You know, hey, I was a witness, I heard them talking about this, and this is what I remember them saying. But you know, memories fade. People sometimes misremember things. This way it's in writing. And also to make sure that before they go into the agreement, both sides agree what they're agreeing to. There are certain contracts that, under the statute of frauds, that must be in writing. One is contracts that cannot be performed within 1 year from the date of the making. So if I said, you know, next year, when you're 25, I will hire you to do such and such. But the time you're only 23, so that would be the contract that cannot be performed within 1 year. A lot of leases can be this way too. Promises made in consideration of marriage, nuptial agreements. Those are required to be in writing in Louisiana as well. Contracts to pay the debt or default of another party. Louisiana, yes. Real estate contracts. Louisiana, yes. And these can cover all sorts of contracts. Leases, shops, timber, ore, sale of houses, sale of fields, farming, all of those have to be in writing. And contracts for the sale of goods valued at 500 or more, those under the statute of frauds needed to be in writing. Most have sort of like gotten away from that because 500 is a pretty low threshold. So most states have a different requirement now. Okay, so you go to court, you don't have it in writing. What can you do to prove that you fall under an exception? Well, if a statement was made in court under oath or at some state during a legal proceeding in which the other party admits that there's an oral contract, then that contract will be enforced, even though it was originally required to be in writing. Partial performance. You start performing, and then you realize the contract has to be in writing. The other's like, oh, yeah, thank you for doing all that work, but I'm not going to pay you because that was supposed to be in writing. I'm not going to allow that. Promissory estoppel, we've covered this a few times. It's an unenforceable contract, but somebody, you know, relied on that contract to their detriment, and the other person benefited. So the promissory estoppel. And then exceptions recognized by the Uniform Commercial Code. And this is where we get into a lot of whether the $500 isn't really material anymore. because oral contracts are allowed in all sorts of specialized arrangements. Okay, the statute of frauds writing requirements. It's not just, if you're going to write it down, this is, and you're going to count it as a contract, this is what they're going to look for. Are the parties to the contract named? Is the subject matter and the purpose of the agreement spelled out? Likewise with the consideration, and it's coming from both parties. And all significant terms are included: the price, quantity, perhaps the quality or the grade of the item. The signature of the party plaintiff seeks to hold responsible under contract. So if I'm the plaintiff and I didn't sign it, but the defendant did, I could use that. And it doesn't necessarily have to be one written thing. It could be broken up into several different documents. Under Uniform Commercial Codes, written contract for sale of goods must include quantity of goods. If you don't have the quantity written down, then it's not really a contract. The UCC allows a variety of written documents to constitute writing, including faxes, emails, invoices, bills of lading, sales slips, checks, or any combination of these. So it might not be the actual spelled out one piece, one document that says contract all over it. It could be any of these other things. Okay, parole evidence rule. So let's say you're discussing a contract and you come up with certain conditions. And then you write it down. And not all those conditions are there. Well, parole evidence is what's in writing, that's all that we can count on. And the reason they do that is to restrict evidence from being admitted that substantially contradicts the agreement in its written form. Makes it more stable, predictable, and it adds integrity to contracts. So even if it wasn't required to be in writing, but you did, you can't bring in other terms that might have been discussed but not put into writing. There are some exceptions. Contracts that are substantially modified, contract conditions on orally agreed upon terms, contracts that are not final as they are part written and part oral, contracts with ambiguous terms, incomplete contracts, contracts with obvious typographical errors, voidable award contracts, or prior dealings and uses of trade. So those really have to be based on the evidence provided to the court. You know, and these are usually sort of ongoing contracts that maybe down the line you make an oral change to it, but you did put that in writing, things like that. An integrated contract is one that it's written following the statute of frauds. It's intended to be complete and final. And general rule is integrated contracts prevent admissibility of parole evidence. So as I said, you know, if it's in writing, you can't later come back and say, no, we discussed something else as well. Okay. So that's the first part of the chapter. I'll cover the other part in a minute. Take a break. Enjoy yours.